Is the other side in your Connecticut divorce or custody case failing to follow the rules and you're not sure what to do? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how to file a motion for sanctions in Connecticut family court. Sanctions are penalties that the court can impose to make somebody follow the rules of the court or to punish them for misconduct. The Supreme Court has laid out that, quote, Connecticut courts possess inherent authority to impose sanctions for litigation misconduct that is dilatory, harassing, or conducted in bad faith. This authority applies even in the absence of specific statutory provisions or rules of practice. So the court does, based on that language, have broad discretion to enter sanctions when there is inappropriate behavior, but there are specific statutes. Most commonly is Practice Book Section 13-14, and that lays out the imposition of sanctions when there is misconduct in the discovery context. So if the other side is failing to provide discovery, fails to sit for a deposition, etc., then you can file a motion for sanctions under Practice Book Section 13-14. But generally speaking, sanctions apply when somebody fails to comply with a discovery request under that practice book section I just described, when somebody violates a court order, when they file frivolous motions in bad faith, or if they refuse to obey the court's procedural rules. And the court can issue a number of punishments. Those can include the imposition of fines or payment of the attorney's fees for the person who has to file the motion for sanctions. They can order that the other party can't introduce evidence at an upcoming hearing if they are failing to provide the discovery, or they can even enter a default judgment, essentially finalizing the case in favor of the person who is filing the motion for sanctions. So this is a sample motion that shows what you actually have to file if you are moving for sanctions. So you put the general case caption at the top, and then you just lay out that pursuant to the Connecticut practice book, the defendant in the above captioned matter respectfully requests that sanctions enter against the plaintiff. Obviously, plaintiff and defendant can be reversed based on which party is filing the motion. In support of this motion, the defendant represents the following. And then you're just going to lay out in detail what actions the opposing party has done that make sanctions appropriate in your particular case. And then you just lay out the relief that you are seeking from the court. And that could include a general statement that sanctions enter against the opposing party. You may be seeking that counsel fees be awarded, additional monetary penalty in order prohibiting the opposing party from introducing evidence at future hearings. You may be asking for that, particularly if it has been a discovery violation, or enter any other further orders that the court deems fair and equitable. I always include that as the end as a general catch-all for the court to be able to order whatever they feel is appropriate. Then you're just going to sign the document and include a certification page. Obviously fill in the blanks and the name of the opposing party so that you give the court confirmation that they have notice of the motion for sanctions. And then once you file the motion, you will be assigned a court date where you'll try to negotiate a resolution with the opposing party. But ultimately, if you can't reach an agreement on your motion for sanctions, you'll have a hearing in front of a judge where you'll present evidence as to why you feel sanctions should enter, and the court will enter orders, and those orders are final. So those are the basics on how to file a motion for sanctions in Connecticut Family Court. As usual, if you have any additional questions, you can contact our office. And if you're looking for representation in a divorce or family law case here in Connecticut, we would invite you to contact our office as well.